we looked at earlier what Amber's likely best appeal is. Of course, obviously, she filed an appeal. And the suspension bond comment never showed up and swept her off the planet because she didn't file her bond. So her appeal is active. We can leave that episode behind us. And Depp's attorneys wisely, I think, strategically, tactically, both filed their own appeal. So the appeal by Depp would seek to overturn the $2 million verdict the jury entered against him because of one of the defamatory statements made by his attorney. We'll look at the basis for this appeal in terms of what are the arguments he can make. Why can he throw that out? I've seen some things on the internet of how can he be held liable for what his attorney does? That's not fair. Or what the attorney said wasn't defamatory. Well, Depp's attorneys had made an argument to the judge prior to the case being over that for various reasons, Depp could not be liable for what the attorney did, even if it were defamatory. And that's what we'll look at because I think that's what they're going to bring up on appeal and whether they have a chance of winning that or not. And whether they can win it or not does not depend on whether, in theory, the appeals judges like Depp. Because a lot of the analysis seems to be, obviously the judge and the jury were correct. The judge is brilliant in terms of the $10 million verdict against Heard. But the judge was so wrong on the law and the jury got it so wrong on this $2 million verdict against Depp. It's not going to go like that. You have to actually look at the law behind it. So they do have some good points, and we'll see, can you be liable for what your attorney says? I mean, you already don't like lawyers, and now you find out you can be sued for what they say. This is just more bad news for people like me. So I think you can look at it one of four ways, and we'll get down to which is the best way for his team to move forward. And one is, you're always liable for what your lawyer says. Let's hope that's not true. On the other extreme end, you're never liable for what your lawyer says. And I don't think any of us are going to buy that. Then in the middle, there's, well, if your lawyer's an agent and you've hired him and he's doing something and you know what he's up to and he thinks he's doing the right thing and he says these things, you could be liable if he's still in the bounds of what he's supposed to be doing. Or if you directly told the lawyer, go out and say this thing about this person, or the person understood that you wanted them to do that. In other words, you authorized it, you knew it was going to happen. There could be some liability there too. So there's everything from always to probably to sometimes to never. It's not going to surprise you. It doesn't look like it's going to be one of the easy ones. So on the always side, I don't think Amber's team even tried to make that argument. And certainly it wasn't made to the jury because the jury instruction said you can find Depp liable if the attorney was acting as his agent and within the scope of his authority as an agent. So nobody was really making the case that if a lawyer says something and they're hired by somebody, you're always liable for that. And there is no good case for that because even if the person is an agent, there are always exceptions to when the principal is liable for the actions of the agent. And generally speaking, it's going to come down to whether they're acting within, the apparent authority or the actual authority that they were given by the principal. So the always liable, hey, good, that one's out. Cool. So Depp's attorneys say that maybe there could be liability for the attorney's statement if Depp directed, participated, or otherwise authorized the statements by the lawyer, and that there's no evidence in the record of that. And that was an argument they made at this motion to strike with the trial judge. However, the instructions given to the jury and the arguments made to the jury are not really based on this. So while I think they probably have a good point here, it didn't end up being the basis for the jury's decision. So yes, if you tell a person to go defame somebody, you could have liability for that. Instead, it did land on this final part of, well, yeah, sometimes you knew it would. And especially in a state like Virginia, which does not have the largest amount of case law developed as some of the more active states have. They will probably after they get these court of appeals running and things. But anyway, this is now in a realm called vicarious liability. So you would be liable for the acts of another person. People get uncomfortable with that. Why should you be punished for something someone else did? That's a natural response. People get arrested for having drugs in their pants. These aren't my pants. This is some other guy's pants. And the idea is, if it's not mine and I'm not responsible for it, how can I get in trouble for it? But obviously sometimes you can. You hire a hitman to kill somebody you don't like. You can't just say, I didn't kill them, the hitman did it. So there is an area where you are responsible for other people's actions. Now, Depp's attorneys start on the extreme end of that and say that the attorney was an independent contractor because the law generally is that you are not responsible for the torts of your independent contractors. You don't control how they work. You don't control necessarily when they work. They're not an employee of yours. You hire them to do a job, paint a house, maybe in this case defend you in a lawsuit, fix your car. These are independent contractors, right? This is not an employee of yours. You're not out there personally supervising how they work. So if they knock a ladder over on somebody or something like that, you're not liable for it because it's not your responsibility to make sure that they're doing the thing safely, as long as you're not creating the hazard yourself. So they make the argument that the attorney is an independent contractor because of the way attorneys work. And there are jurisdictions where the attorney relationship has been defined that way, sometimes to just avoid this sticky situation of, if the attorney is an agent, the scope of the agency and how that was authorized gets right into attorney-client communications, right? How are you going to prove it if you can't talk about that? And in fact, in the Depp case, the attorney would not talk about it and cited the privilege. So some jurisdictions have navigated that by saying, yep, it's independent contractors. And obviously the way to solve that here would have been to sue the lawyer directly for the tort if they thought that he committed the defamation, and not try and hold Depp responsible for that. They weren't being prohibited from doing that. What they are trying to do is make Depp responsible for what the lawyer said. So there are jurisdictions where I think the independent contractor argument is very strong and could result in the verdict being thrown out. I'm not sure Virginia is one of those states. And certainly the judge, who I thought was a very good judge, she didn't think that either. So there are times in a lot of jurisdictions, and probably Virginia, when an attorney they are an independent contractor, they're not your employee, but they can also be an agent. There's no reason in your mind why somebody can't cross the threshold from being an independent contractor to be an agent. It's not like, well, you just can only be one or the other. You can have an agent for a limited purpose and they go back to being an independent contractor. They may not even be being paid and be your agent sometimes. So, as a lot of things in the law, it depends, right? So the jury instructions were to find out whether the attorney was acting as an agent, and whether, when he was speaking this defamatory content, whether he was within his apparent or implied authority to do that. In other words, was he doing what Depp wanted him to do as an attorney, which is defend him maybe in the court of public opinion or whatever, and he made these statements? And if he did, that was within the scope of what he was doing. It's not like Depp hired this guy to close a real estate transaction for him and file, a deed down at the courthouse, and then the guy runs off and gives an interview and says, hey, by the way, I just want everybody to know that Amber Heard's a big fat liar and everything she said is false. Depp would have no reason to think that attorney would speak on that issue, right? So they're trying to say here, the jury needs to conclude from the evidence that what this attorney was engaged for related enough to this that they can say, yeah, he was within the scope of what he was hired to do. So therefore he became an agent for purposes of what he was saying. That's the argument that Heard's team has. That's the argument that the judge agreed with. So the instructions were given to the jury whether they would find that he was an agent and was acting within the scope of his authority, and therefore he could potentially be liable for this. Depp's team doesn't give up on this idea that the verdict is still wrong, even if he could be liable as an agent, because they say there was no evidence given in the trial to show that he was acting within a scope of agency or with any kind of authority, because basically they didn't get into that because it is privileged. Then they do have an argument that the jury's verdict is necessarily compromised because it couldn't be based on any evidence because there was no evidence there. I don't think I'd throw the verdict out on that, though. The guy was his lawyer, and there's no indication that he wasn't acting in the scope of his agency. He kept on being hired. He was saying these things and defending Depp vocally. Why would anybody think that, based on the actions he took, that he was outside the scope of an agency relationship, if an agency relationship existed? So I hear what they're saying. It's not frivolous, certainly, but to me, it's not enough to throw out a jury verdict. I think that you could say there was some evidence there. So that's the main battleground for this appeal, and it doesn't sound so good for Depp when you look at that. Of course, he wasn't going to appeal this anyway because he wanted the case to be over, and they're really filing this appeal because Heard filed her appeal. But they also have one intellectually interesting argument. I don't know that it's going to be successful, which is that the tort in this case required mens rea. In other words, it's got this mental component to it. In fact, it had to be made with malice, right? So the statements when made should have been made either recklessly knowing or recklessly disregarding whether they were true, or knowing that they were untrue. That's malice. And Depp's attorneys say that while the agent's knowledge is usually imputed up to the principal, in other words, what the lawyer knows is imputed up to Depp, they don't see the case law that shows that Depp's knowledge, intent, and that sort of thing come back down to the lawyer. And so they say, and they cite pretty good case law, which is if the agent doesn't commit a tort, there's nothing for the principal to be vicariously liable for because there's no underlying cause of action. So they say you had to have had evidence that the attorney himself had malice, that he had to meet every element of the defamation tort, including malice in this case, in order for him to be found to have committed a tort, and then if it's in the scope of his agency, Depp's responsible for it. And Depp's attorneys say, whoa, they're mixing here. They're saying that the attorney could say the things without necessarily the intent, and then Depp has the intent, but he's not saying it, and you're imputing Depp's knowledge and intent over to the lawyer, and you're mixing this up, and there's no case law that says that the knowledge flows down, only that the knowledge flows up. I didn't see that in the jury instruction, although maybe I missed it. I did hear it, however, in the closing argument, as Depp's attorneys say, when Elaine was talking about, they're back and forth, they're the same people, Depp and his agent, for this purpose. And they are for vicarious liability, not necessarily for everything that they do, right? So Depp's, how many angels can dance on the head of a pin kind of argument about, whose knowledge is imputed to who, therefore is intellectually interesting. And I don't think there's specific case law on it in Virginia. However, that doesn't really sound like a winner, does it? So all in all, to me, that if you survey the nation's laws, you can find all these arguments for why maybe the judge was wrong. There are not, that I saw, direct cases on point involving defamation and third parties in Virginia that necessarily control the outcome of this. Because there are a lot of things in Virginia that there aren't cases that directly control. They're novel issues of first impression are just slightly off the beam of decided cases, and this is one of them. So I can't say his appeal is going to fail, but I do feel like it's not going to win. The odds are against it. Same way I think that Heard's appeal is unlikely to succeed. To my mind, the judge ran a good trial and a fair trial. She tried to stay in bounds of what was fair. She tried to stay in bounds of what was the law. And that, to me, she applied to both sides of the case. She wasn't one-sided one way or the other. And I think her judgment was sound. So if I were betting, which I'm not, I would say both appeals fail in this case. And it's a big fat waste of time. And eventually, for God's sake, somebody get this case to be over. But I could be wrong, and doesn't really matter because this case was for Depp's perception that he wanted to restore his name, and in large part I feel like he's done that with a lot of people. At least he got his side of the story out there and let people see where he was coming from, and that's what he wanted to do. He did it. The jury agreed with him, and I can't imagine they would all go back to another trial. Even if this got reversed, they'd probably just let it go. But likely this judgment's going to stand, in my opinion. But I did want to clue you into what I see as Depp's appeal coming up on this, since we did Heard's. We'll see what the Court of Appeals does. Remember, it's going to be boring because they're going to file these briefs, okay? And then people are going to, if they can get a hold of the briefs, they're going to read them, they're going to misconstrue them, they're going to give you partial information about them. It's going to be confusing because it's going to be on legal issues. Then the attorneys have a very short period of time, like sitcom level amount of time, to make an oral argument to the court, which they usually live stream, either audio, sometimes audio and video, but it will just be the lawyers making a very quick presentation. The judges may ask some questions if they're curious about some questions of law that they feel like could be explored a little bit past the briefs, but they're already going to know where they stand pretty much at the time they have that hearing. That's how appeals work. Then it'll go away, and in secret, they'll write up a decision, and then they'll issue it, and then we'll see where we stand at that point. Thanks.